So as usual, welcome. And we are here to talk about SMILE, the First Amendment audits in libraries. This is the disclaimer. Because I deal with issues relating to law, I have to let everyone know that we are providing information today, but we are not providing legal advice. You should contact your attorney if you have specific issues or questions about this topic relating to your library. As everyone probably knows, here's my contact information. I am, as always, open to any questions, comments, whatever I can do to help you. I have to let you know, I get them fast and furious, and I try to address them as quickly as possible. So it may take a few days for you to hear from me, but don't despair. If you have a time crunch, or you have a board meeting, just nudge me. Don't be shy. Just send me an email that says, hey, I sent you an email, I haven't heard from you, and I will address it. But I do take them in the order in which I receive them. So that's why sometimes it may take a little while. We have a survey at the bottom. If you would answer the survey, we'd very much appreciate it. If you'd answer the survey, it really helps us. It helps us address our sorry, just lost my train of thought. It helps us address how we're doing on webinars. It also helps us figure out new webinars to offer, and we appreciate any kind of input that you can give us. Okay, let's jump into it. So when we talk about First Amendment audits, it's right there in the title, and we just start with the First Amendment. And in case y'all haven't, we all kind of know what the First Amendment says, but it kind of helps sometimes to actually read the language. So the language of the actual First Amendment of the United States Constitution says that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So the First Amendment packs an awful lot into that one paragraph, right? It kind of is a deck of a lot of the freedoms that we think about when we talk about, our constitutional rights. The one we're really focusing on today is speech. Abridging the freedom of speech or of the press. We're also going to touch a little bit on petition the government for a redress of grievances, but that's really kind of ancillary. It's really all about the freedom of speech. Now, I'm going to give you a couple kind of legal background basics. So bear with me here, because if you have this foundation, it really helps to understand. This is more like context. It helps you kind of understand the issue of First Amendment audits a little bit better. So as you can see at the bottom of the slide here, in 1992, there was a case called Crimer versus Bureau of Police for Town of Morrison. And this is a Third Circuit case. For those of you, you may know that the United States, in terms of the federal court system, is broken up into circuits. So there are approximately 11, I think it's 11 circuits right now. And those circuits each correspond to kind of groups of states, right? So they're regional. Michigan's in the Sixth Circuit. So a Third Circuit case is not binding on the state of Michigan, but it is important, and for purposes of general federal law, it is also this particular line of reasoning has also been adopted and followed by many circuits, including the Sixth Circuit, which is Michigan. So even though this particular opinion is not binding, this concept we're going to talk about, which pretty much was first memorialized in this decision, first put into writing in this decision, is represented in law that Michigan follows. And this case specifically had to do with a homeless person, a homeless patron, who went into the library in Morristown And he proceeded to, the library had a rule or a policy that said that if you were in the library, patrons of the library, in order to use the library, had to be actually using the library. They had to be reading, or they had to be researching, or they had to be, studying. They couldn't just be laying around, or they couldn't be sleeping, which is a policy that's not necessarily unlike some that many public libraries have. Well, this person said that this particular policy was abridging his constitutional rights, was violating his constitutional right to information and to free access to a library. And so the court, in its decision, said that, what came out of this case was that, libraries do have the ability to have rules and restrictions to facilitate the use of their library, their facilities as they're intended. So one of the things the court said here that is pertinent to what we're talking about today is that the First Amendment, right here, this particular quote, it says, "The First Amendment does not merely prohibit the government from enacting laws that censor information, but additionally encompass the positive right of public access to information and ideas." So this particular opinion really solidified the actual constitutional right of information. So the right of people to receive and to access information. And then it connected that right to public libraries. So it connected the right, the constitutional right under the First Amendment and freedom of speech for people to access information and to acquire information, connected it to public libraries as the place where, the commonly accepted place where people could access information, right? So the idea is that public libraries are a place that all of us are familiar with, and all of us know are a place that we can just walk in any public library and research or look material up. We may not necessarily be able to check things out if they're not our library, but we can walk in and use the information. And so the court determined that because of that, not because of that, and because of the way that public libraries work, that public libraries were kind of very strongly connected to this right of information. Now, as part of this decision, one of the things that this particular crier decision said was that libraries are public forums, right? So there are three different kinds of public forums. And this is important because not only do you have this right of information, right, for libraries, but then you also have to know that libraries are government entities. And when you talk about freedom of speech and you talk about, First Amendment audits, part of the issue here is access to the building, right? And the rights that you have as it connects to that particular facility, right? So as far as US law is concerned, and federal law is concerned, and constitutional law is concerned, is that when you're looking at government facilities, you have three different types of facilities, which means kind of three different bucket of rights, okay? So you have general public forums. And a general public forum, when you're looking at freedom of speech, are things like the general sidewalk, the public square, right? So if you think of the traditional colonial public square, where people would just stand on boxes, like they would say soap boxes, the wooden boxes, and they would just speak, right? And they could pretty much, the idea was that they could say anything they wanted, right? They could say things against the government. They could espouse pretty much any kind of theory that they had or information that they wanted to impart. So it's unfettered, right? They can just kind of say whatever you want in a public park, right? Or you go to Times Square, or you go to the sidewalk in front of the Capitol. You can pretty much say, whatever you want to say, even in your own town. You get on the sidewalk, or you get in the street, or you can just, kind of say it's a public forum. Now, with that, there's also no expectation of privacy in a public forum. And, as far as speech goes, which is kind of a little bit outside the context of what we're talking about today, but there are some limits of speech, even in a public forum, right? You've all heard about things like yelling fire in a crowded theater. So, certain speech that could incite violence. But for purposes of today, we're talking about just general expression. And so in the public forum, the general public forum, the public square, you can pretty much just say what you want. The next level is a limited or designated public forum. And you will see these two labels used kind of sometimes interchangeably. Some courts say limited, some courts say designated, some courts actually parse out differences between limited or designated. It depends on what source you read. And I think actually that distinction is a little bit beyond the scope of what we really need to discuss today. So I put them together because you very often will see them in a lot of kind of more, less super technical legal things. You'll see them interchangeably. And designated or limited public forums are public forums where you can have a certain amount of restrictions, right? It's not as open as a public forum. So things like, libraries are designated public forums. There are schools, there are certain other areas where, you can make time, place, and manner restrictions, and that means that the entity can limit behavior or limit speech within that forum. They can't necessarily limit speech based on the topic of speech, right? Or the actual content of speech. But what they can do is they can limit any kind of expression that could possibly inhibit the use of the forum for its intended purpose. So to put it plainly, you can have rules in your library that are designed to ensure that patrons can access the information that they need to access and that the library can operate the way for its intended purpose, right? So it can operate so that people can go in, obtain information, check books out, attend programming. So, any kind of behavior that could possibly interfere with this, libraries can restrict. So that kind of forms the basis of things like patron behavior policies, things like petitioning policies. These are all kind of based on this idea that time, place, and manner. You can have restrictions to, limit disruptions or the interference of access to information or interference for the purpose of the actual facility of what a library is meant to be. The non-public forums are things like, actually courthouses are another limited or designated public forum. A non-public forum would be like a military base or something like the CIA or, entities that, really there's no, for different reasons, there's no public access or very, very little public access. And so and that's the most restrictive forum. So there's very little, excuse me. So these are the three specific types of public forums that govern speech and expression. Now, I do want to mention that within public forums and limited or designated forums, you could have within them some non-public areas. So within the library, for example, you have your public spaces, the reading rooms, the areas that are designed for the public to access information, but then you also have staff spaces. And those staff spaces would be a non-public forum, right? Because those staff spaces are not public spaces. The intent of those staff spaces is not for access to information. So that's something to kind of keep in the back of your mind as well. So again, this is a kind of an overview. As I said, a library can limit First Amendment activities that are not in keeping with the purpose of the library. Now, when we talk about First Amendment audits, a lot of you may have heard about these because they kind of goes up and down, right? So you you hear about them for a while and then you don't hear about them for a while. Different areas of the country kind of have spates of them and then it kind of dies down and another area of the country gets them. And essentially, First Amendment audits are when typically a group of people or a person, a lot of times it's at least more than one person, arrives in the library. A lot of times they'll announce that they're doing a First Amendment audit. Very often they tend to be very intimidating. It's a group of people or a person that tends to have a fair amount of knowledge about what their rights are. A lot of times they're pretty astute. You know, they've done their homework. They know that they have a right to public buildings. They know that they have a right to photograph public buildings and public officials. But the piece of information very often they're missing is how libraries differ. You know, and we kind of laugh about that libraries are different. And libraries really are different in a lot of areas of the law, right? So libraries are, in Michigan at least, libraries are government buildings, right? They are government facilities, but there are other aspects of libraries that tweak that facility idea a little bit in that it makes them not so open to certain rights that they may have in other facilities. For example, you walk into the post office and you absolutely have a right to record and photograph. And, you know, it's pretty well established that members of the public do have a right to photograph public officials completing their duties. But when it comes to libraries, you have a very big kind of wedge that goes into this, and that's privacy, right? We have the Library Privacy Act. And then you also have this whole idea of not impeding other people's access to information. Now, a lot of these First Amendment, people are people that, they'll just walk in and openly record, right? And what they're hoping to get is a rise out of people, right? So what they want to do is cause conflict. They want to cause a disruption. They want to cause, a discussion, and they want to cause, hopefully, some kind of incident that they can record that make it very interesting for people to watch. In a lot of ways, they're not as interested in really their rights as they are in being able to catch some really good video. And so let's explore a little bit about the background behind these First Amendment audits. So if you look at our culture and how recording of live events has occurred, if you reach back into the early 90s, one of the very first times we saw this idea of non-journalistic. So I'm not talking about like the news or reporters and cameramen live recording things. I'm talking about members of the general public. One of the first times that this really happened was in 91 during the LA riots, when the video of Rodney King surfaced being beaten by police. And so this was taken by a gentleman, and this was really one of the first times that a member of the public stepped up and took live video of this kind of newsworthy. I guess you could go back to the Zapruder film in Kennedy's assassination, and that would also be an example of this. But since 1991, if you look at the way technology has grown, right? So we, came to cell phones and we came to smartphones, and it became easier and easier with technology to take these pictures on the ground, right? And so now you come to today, and this is very common. It's just second nature for us all to whip out our phones and take pictures. And so now it's become a really powerful activism tool. And for some communities, it's considered a measure of protection. It's an effective way to call attention to certain government activities and potential wrongdoing. So it really can be a very useful and powerful tool to promote change and to promote, if you will, positive change, depending again on your point of view. And now news outlets actually solicit citizen recordings, especially when disasters or sudden occurrences and protests, a lot of, very established news outlets will ask for cell phone recordings. And some of the most compelling videos we get are from citizen cell phones. So it's actually become a really powerful and a really useful way for the American public to get information about their government, and it has increased transparency of the government, right? Particularly when it comes to things like law enforcement and other higher level government activities. But at the same time, just like any other tool, a tool can be used for positive, what some people feel is positive purposes, and then it can also be used for problematic purposes. One thing to remember about First Amendment audits is that, and I think sometimes this gets lost in the hubbub of, First Amendment audits can be scary, they can be very intimidating, it can be traumatic for library staff, it can be, at the very least, it can be very annoying. But it's important to remember that even though this concept has, in a lot of ways been turned into a kind of negative thing, this is actually rooted in real rights that we all have as people living in the US. We have a right to access public buildings, right? Depending on the building, you may not have right to access every part of that building, right? Even look at the, the Capitol, the DC Capitol insurrection, right? We all have the right to enter the Capitol building, but we don't have the right to go to every portion of the Capitol building. Just like in the library, you don't have the right to go into every portion of the library. You can't go, behind the staff areas, right? But you do have a right to access to public buildings. You also have a right to observe and record public officials completing their duties. This is key to why you can record the police and not get arrested for it. Or, if you do get arrested for it, it's wrongful, because you do, as long as you're not impeding their ability to do their job, and you're not negatively affecting the operation of the government entity, you have every right to record public officials completing their duties. A public employee doing their work has no expectation of privacy. So, whether you are a library employee or whether you are a police officer or a fireman or a mayor or a library board member, if you are a public employee or a public official, you do not have an expectation of privacy while you are doing your work. Now, that doesn't mean that people can interfere with your work, right? So that there's a fine line there. And that doesn't mean that the patron does not have a right to privacy, right? So if you're a library employee and you're sitting there working on patron records and someone takes a picture of you and captures your screen, that can be problematic. So again, there are shadings here that is important to be aware of. But when you have somebody just say, you can't take a picture of me, or I don't like it when you take a picture of me. Well, if you're a library employee, that's, that kind of goes with being a public employee. But again, as I said, there are shadings to it. And we're going to talk about that a little bit later when we talk about policies and how to deal with this. You also have the right to record and photograph public buildings. Now, one of the things that's interesting here, and we'll talk about a little bit more later, is that a real problem that has happened in the past, as we're finding out, more and more problems that have occurred with certain communities in our culture, is police historically, and I'm not saying right now, and I'm not saying every police department, and I'm not saying every area, but it has historically been an opportunity, people taking pictures of public buildings, particularly journalists or tourists, and particularly journalists and tourists are of color or of certain marginalized communities. Police will sometimes use this as an opportunity to harass people. And that can eventually turn into an arrest. So, it is important to understand that everyone has the right to photograph a public building. Whether, again, as long as you're not impeding the operation or the entrance or exit of the public building. If you're just, taking a picture of it from the sidewalk or, from a corner, you're perfectly allowed to do that. And you should not be harassed for that. But you do, even though these rights exist, right? So there are some balancing, as we mentioned, this particular right and this tool that we have to take live recordings and to promote transparency and to take recordings of public officials and police. One of the things, that has occurred is the advent of social media has kind of made this business of providing content. And again, depending on your perspective and depending on your political leanings and depending on your point of view, you may consider some content good and some content bad. The fact of the matter is, people who do this, who obtain content, whether it's live recording or other kinds of social media content, they make money on it. If they get lots of followers, they can make money, and they can make a lot of money. And, sometimes it's the more salacious, the more contentious, the more in your face some of this content is, the more subscribers they get and the more money they get. So in a lot of instances, it's in the best interests of some of these social media people to get content that's conflict and that is contentious. Now, it's also true that there's been a lot of anti-government groups lately have come to the forefront. Not that they haven't always existed, but I think we're finding out about more now. And certain popularity of different government conspiracy theories and anti-government sentiment have increased the attractiveness of some of these audits. Now, a lot of the audits that you hear about in big cities and a lot of the audits that libraries are going through are perpetuated by people who have these social media accounts. There's a lot of different websites that encourage people to do this. People who are upset at the government for different reasons have they're inspired or they're encouraged to undertake this activity. And I'm not passing judgment. A lot of people have very legitimate, griefs against the government. And a lot of people feel it's important for government to provide as much transparency as possible. But it's not the why. A lot of times it's the how that is the issue here. So it is a fact that a lot of these First Amendment people are social media people. They're people that have high subscribers on their channels. They are people that make an awful lot of money doing this. And it's in their best, and what they want is to create controversy for their channels. A lot of these audits are not rooted in any real problem with government transparency. A lot of them really are rooted in this idea of entertainment or this idea of generating lots of conflict. And it may be that there's an ultimate goal to show how restrictive the government is or how much the government hide things. But again, the method is through this idea of let's create as much of a show as we possibly can to get those views and to get the money. So as I mentioned, in reality, a lot of these auditors are social media personalities. And to them, the more crazy and contentious the video they can get, the better off it is. And so why is this a problem for us? Well, obviously the big problem is that, they are very intimidating and they can be extremely aggressive. If you look at some of these videos on YouTube, they can be kind of frightening, right? Especially depending on the time that they occur, depending on how much staff is in the building, depending on the staff that happens to be at the desk when this occurs. It can be extremely terrifying, and it can be extremely scary. They disrupt the staff, they harass staff, which means they can impede library operations. They can interfere with other patrons' ability to get their information. If you witness this as a patron, you witness one of these, again, it can be very scary and very intimidating. And so, I wouldn't want to walk into a library at the time one of these is happening the way that I've seen some of these YouTube videos. So it would certainly deter me. And that's, that's specifically the time when a library can implement some kind of rules or restrictions to prevent that kind of intimidation or deterrence from exercising your right to information. Also, unfettered recording within a library can cause library privacy problems, depending on your state and depending on the law. At least here in Michigan, you cannot disclose library record. And a library record can be something as simple as an identifiable face looking at an identifiable library material or an identifiable book. So if you're just willy-nilly taking pictures, you can capture computer screens, you can capture, people's identifiable features, holding books or checking out books, and that can be a real problem. And lastly, it can really, if you look at how some of these occur, right, the idea is they build the intimidation and they escalate. And depending on how the library staff reacts, the situation can escalate pretty quickly. And when that happens, it can actually turn into a much more dangerous situation that goes beyond a First Amendment issue. And that, especially nowadays, that is something that is important for a public facility like a library to really try to keep a handle on and to, minimize the possibility of, because, nobody wants anybody to get hurt or to have any real significant damage occur. So let's talk about what a library can do about this. This is really kind of touchy because some of this depends on your point of view about this. The American Library Association, if you look at the Office of Intellectual Freedom, they take the position that libraries really kind of have to make their own decision on this. And that makes a lot of sense. And I think for most policies, that's what has to occur. But when a library is looking at this issue, one of the things they really have to balance is, that public right against the privacy and the safety issues and the interruption of operations and the impediment to information that could occur. So it really can be a kind of a delicate kind of balance, right? And when you're looking at doing policies. It's also important as part of this process is that when you're a library board and director and you're looking at this, you really want to look at all your options, right? So it's very easy to have a knee-jerk reaction and say, well, we should have a ban on all photography. But, you may really want to sit down and really, consider what all of your possibilities are to control this kind of situation or to mitigate this situation. It could be that a ban on photography is exactly the right step for your library, but it could also be that maybe that's going to be more trouble than it's worth if you look at the actual likelihood of a contentious First Amendment audit in your particular library. It can happen anywhere, okay? But, there are, obviously certain areas of the country and certain situations that could make it more likely. Right? So while I totally recommend that every library is prepared because you do never know, it really does make sense for a board and a director to really sit down and do their homework on this and to also consult other experts. So when you look at policies, obviously, one of the things a library can do to prepare, as we discussed, is libraries have every right to have a policy on this because for the reasons we mentioned, it can impede the ability of members of the public to access information in the library, to use the library for its intended purpose, which is the textbook definition of a time, place, and manner restriction. And so you could have photography policies. You would want to have a problem patron policy anyway. And by problem patron, I mean behavior policy, right? Because when you get right down to it, there is an issue with photography as far as privacy is concerned. But the real issue here is the behavior and the intimidation. And then you want to have a threat or emergency policy, which, is something, again, every library should have. How do you train staff, and what is the procedure when something escalates and there is a sense of real danger or real possible imminent harm? Training is really important. You want to make sure that your staff are trained in conflict and difficult conversation management. And this is something that has actually been in an uptick during the COVID period because of the contention over masks and other restrictions. Here at the Library of Michigan, Web Junction and Niche, we have lots of really good interactive courses on these topics: conflict management, difficult conversation management, how to handle difficult patrons. And I would recommend that every library staff member who works on the front lines, and actually wouldn't hurt for every library staff member, period, to have to take these CLAP courses. They're not long, they're not difficult, they're not even that onerous. I've taken most of the ones I've been able to find, and they are truly helpful. And the more that you can empower your staff to handle things like this, and the more confident and secure your staff feel, then most likely the better the outcome of this is going to be. And we're going to talk a little bit more about that in a few minutes. I would also suggest some diversity training. And part of that is because of the unique role that live photography plays, particularly within BIPOC communities. And we're going to talk about that a little bit more too. So the more that your staff understand about why someone might be taking a photograph, right? Because it's pretty obvious when you have a First Amendment, auditor. But if you're going to have a photography policy, then it's got to apply to everybody, right? It can't just be for, the intimidating looking guy who walks in with a friend who's videoing. It has to apply to everybody. You can't selectively enforce this policy. That is a whole other problem. So if you're going to have a photography policy, you really need to think about, well, you have to train your employees on enforcing it. And you might want to take into account things like, what other circumstances do people take pictures or photos or recordings? And then you want to make sure you market your policy. You want to market and notify your community of this policy. Look, we have this policy in place. You don't have to call it your First Amendment audit policy. You can call it your behavior policy, your photography policy, your recording policy. But you want to make sure everybody knows about it, because not only may that, slightly deter First Amendment auditors, it may not, but they may realize, what, this is going to be too much of a hassle. And we're just going to move on to somewhere else. But it puts them on notice. And if they're on notice, again, it makes it easier to enforce, because that's part of the due process of a policy. It also can reduce your interactions with non-auditor patrons who just want to take pictures in the library. Now they're on notice that there's a policy, right? And then they, either can ask about the policy, ask if they can take a picture. And, again, that's something your policy may want to address. But then again, that puts your staff in the position of not creating a different kind of conflict by, enforcing or negatively having an interaction with a patron who, meant no harm or meant no conflict. It just kind of puts everybody in the know right away. And then other kinds of patron education. You have your use, as they say, different interactions as teachable moments. So if you have a patron that wants to take a picture, then it's a way that, the staff member can address the issues and explain to the patron, well, this is why we don't permit photography, or this is why we only permit photography in this particular way. And then that lets your patrons understand what some of these issues are. So again, when you're talking specifically a photography policy, you have to decide ban, partial ban, require notice. There are samples, and I have some links to different samples in my resources slides. You know, there's libraries do a variety of things. Now, there are some libraries in the countries that are not government entities, right? They're not government buildings, and they have a whole different kind of rule. But there are plenty across the country that are government entities, and there are some really good policies out there. You have to, like with every policy, you have to consider how your policy is going to be enforced, and how, you know, people who violate the policy can appeal the policy. You want to also, and I think this is a big one, you have to consider your individual library circumstances. In Michigan, we have a lot of libraries, and the American Library Association brings this up too. There's a lot of libraries that, for one reason or another, may want to encourage people to take photographs. So it may be a library that has a very interesting backstory. Like, I'm going to make a shout out to Topinabee, whose library is literally in, you know, a train car, right? Or, you know, a small train depot. It's very unusual. It's very charming. It has some historical significance. It's kind of almost like a tourist destination in that town. So that's something where people frequently take pictures. If you have a library that has a very unique or historical architecture, or, you know, you're a Carnegie Library or the Detroit Public Library that has books written about its architecture. If you have a very unique collection of art or of historical artifacts that people may want to take pictures of. You know, you go to Washington and you go to the Library of Congress, or you go to the New York Public Library in Manhattan, and it's almost like a museum. So a lot of times when you have you have something special in your library, whether it's a piece of art, whether it's a amazing children's area, you know, where you want to encourage photography because you're proud of it, and you want people to see it. How are you going to manage that? You know, maybe you're going to have postcards that you can sell or give away. But you have to keep that in mind, because if you're going to have a ban on photography, that doesn't necessarily jive with encouraging, you know, non-threatening patrons to take pictures or all the pictures they want, right? Because again, it can be problematic to selectively enforce policies. So you want to really consider that. Think about, you know, again, why would people want to take pictures in your library? Is there reasons why a non-First Amendment auditor would want to take pictures in your library? And then you may want to work out a policy that accommodates that ability. You also want to consider the effect of your policy on different portions of your community. And this just recently I've been researching First Amendment audits since last year for a while. And this particular attribute just recently came to light for me. I've been working closely with a library board member who is a DEI expert, and she is a member of the BIPOC community. And she mentioned to me when we actually were discussing this, that in the BIPOC community, especially right now, their smartphone with the camera and recording feature is considered an essential safety tool. And you know, the way it was put to me is, I would never leave home without my phone, because you never know. And that, you know, struck me, that, you know, a lot of members of this community, especially when you're talking about government entities, you know, they look at their ability to live record as a safety net, to ensure that their rights are going to be represented and that their voice is going to be heard. And so that is also something that you really need to, I feel that a library should really consider. If, you know, again, depending on your community, depending on your circumstances, that, if you're going to have a total ban on photography, then, and there's a discussion in the library, or there is a disagreement in the library, and a member of the BIPOC community pulls out their phone to record the interaction. Again, if this is something that is possible to occur in your library, or depending on your demographics and your community may be likely to occur, you may want to factor that in to your photography policy and how that would be handled by staff. And I would encourage, a consultation with your attorney on this. Does this mean that you can't forbid? No, it does not mean that you can't forbid, you know, recording of things like that. But there may be other ways to handle it that won't escalate a situation. But it's more of an understanding of how these types of policies can affect and have an unexpected effect on different parts of your community. It's just all about, thinking and doing your homework. And then you also want to remember that this policy is going to work both ways, right? As I said, it's very common for us today to whip out our phones and just record. And I have 2 college age kids, and I think that the phones are permanently glued to their arms. I think that that's just their appendages now. They are literally never without it. I think that it's just the way things are now. And so one of the things for the library to consider is staff behavior, right? A staff policy. Is that photography policy also going to apply to staff? Because if there's a blanket no photography policy in the library, then if something happens that's either interesting or curious or contentious in the library, then a staff member, may be tempted to pull their phone out and record it. And so I think also that's something that would have to be addressed, as well as the patron side of it. So, again, as we mentioned before, you want to make sure that staff are trained on how to deal with not only First Amendment audits, but also, as I mentioned, any kind of contentious interaction with patrons or people that walk into the library. As far as First Amendment audits are concerned, one of the most important things to know about audits is they really want to stir up contention. They want to create conflict. They want to have someone freak out on them and yell at them. And, they're really looking for a spectacle. So the more that your staff can remain calm and professional and ignore them, the better it is. The more likelihood it is that the auditors will give up and leave. And again, it's a balancing act, because if they're intimidating other members of the public, if they're, interfering with patrons' ability to use the library, then those are all things that would have to be, dealt with. But, all things being equal, if none of those things are occurring, or it's just the start of a First Amendment audit, sometimes the best advice is to do nothing. Even if you have a policy, which again, everyone should probably have one, just ignore them. Because again, if you don't play their game, then a lot of times they'll go away. I would say 8 times out of 10, they're going to go away and find a better hunting ground. Because as I said, they go to post offices, they go to police stations, they go to government buildings like, town halls and city halls. Make the library a place that is not interesting to them, because you're not going to rise to their intimidation. If you have security personnel, have your staff defer to the security personnel and just not engage. And you may want to check with your security personnel on what kind of training they have had for this kind of situation. Because again, libraries can be different. And if you have security personnel that is used to working in municipal or government, entities or government facilities, they may not understand the difference between a library and a town hall. And so again, that's important to address with them. So if you have security personnel, I would take a few minutes to engage with them and find out what they know about First Amendment audits, what they're trained, how they're trained to deal with First Amendment audits, because a lot of, especially professional security personnel, if you contract with an outside service, they're given their own separate training and they have their own protocols. So it can be very useful for you to understand what their protocols are so that you can inform your staff and so that you can address with them any tweaks that may be required, because a library, as we've said, is different. If the behavior of the auditor is harassing, have your staff, put your staff on notice that if they're being harassed, regardless of the reason, they should implement their procedures that they use to handle any kind of problem patrons. Because at this point, they're not policing speech, they're policing behavior. The minute it goes from, I want to take pictures, to I'm screaming at you and my face is right up against you, it's no longer about the First Amendment. It's about behavior, and it's about intimidation, and it's about aggression. And as I said, there should be a policy in place for the library to address that in any situation where that can occur, not just First Amendment audits. And if necessary, ensure and assure your staff that they can call law enforcement if necessary, for support if they have a very problematic situation, because not only is it important for them to protect their safety, but they also need to make sure they protect the safety of the patrons in the building as well as their right to access information. Part of all this process and of doing your homework and figuring out what you want to do, your attorney should be right there with you. I would strongly recommend that if you don't have an attorney on retainer, you get one. I understand that this can be a little bit expensive, but I think there are ways to do it that can fit within multiple levels of budget. Just because you have an attorney on retainer doesn't mean you need to call them all the time, but the idea is that when you need them, you use them. And I think this past year has taught us that attorneys can be worth their weight in gold. They can really end up saving more money than they cost. And just peace of mind and knowing that you have everything done right and that your policies are all in line with the law can be just very reassuring and can highly lessen your possibility of liability. Law enforcement, contact your local law enforcement. If you have a good relationship with your law enforcement, just talk to them about if they've experienced First Amendment audits in your community and how they, what they've done to respond. Now, keep in mind that, police have a different, are different than libraries. Libraries have a little bit more ability to restrict things than police, law enforcement does. But it doesn't hurt to compare notes and to get an idea of if this is happening in your community. Same thing with your municipal partners, your town hall, your city hall, your post office. Check with them. Have they had First Amendment audits? What happened? What is their way of handling it? Check in with your other library colleagues. Check in with, this is something that happens at universities. So if you have a university in your community, contact the library there and ask if they've dealt with this and what they've done. Again, universities have a little bit of a different responsibility, but the library's responsibility should be not that much different than yours, unless of course it's a private school. But even if it's a private school, if the library is open to the public, then there could be some very close similarities there. And a library that has government documents is, must be open to the public, at least a certain measure. And other public libraries, you can also, I did put some, as I said, in my materials here. I put some in my resource slides, but you can troll around for sample policies. Other state library entities have been talking about this. There's a ton of articles in the Library Journal on this. The Office of Intellectual Freedom at ALA has a section on this. There's, sites that are dedicated to journalists have lots of really good information on this. And I've included a lot of those links in my resources. So there's a lot of ways to get information. And I think that if you have the information, you don't really need to be worried about this. You don't need to be afraid of it. It's just a matter of being prepared, like with most library things, right? Most in, negative interactions, or most things that could happen in a library that are a little bit or very intimidating or problematic can be made much better by preparation. And that's really kind of what we're talking about. So then here's my resources, and I will be adding more to them before you get these slides. Thank you. It looks like we do have some time for questions. If you would complete the survey, again, I would very much appreciate it. It really does help me not only improve my webinar skills, but it also, on my presenting skills, but it also helps me figure out what types of things you like to see, and what types of things, are interesting for people, for me to present on. So it's very helpful to me. I see that there are some things in the chat. I'm going to stop sharing. And I'm going to take a look at the chat and see if there's any questions in here. What if someone is harassing others by entering the library? Right, absolutely. If you have a patron, whether it's a First Amendment audit or not, who is following people in the building, then again, that would be impeding other people's ability to use the library. And I think what you want to have, and every library should have, a policy that specifically says that behavior that interferes with other patrons' ability to use the library, and I would, again, confer with your attorney, but you could even, list such as following patrons, harassing patrons, soliciting patrons. You could, that's perfectly, we had policy like that in the law libraries I worked at, where members of the public would come, because since the libraries I worked in were mostly law schools, and so there were law students working, some members of the public who were handling their own legal affairs would come in and then look for free legal advice or free legal help. And so they would go desk to desk and bother law students who were studying. And law students can be pretty vocal about not liking that. But, we would have a policy that essentially said, look, you're here to use the library for this purpose. And if you're going to, interfere with other people's ability to use the library, we're going to have to ask you to leave. And that's what I would recommend. And also, again, confer, if you have security personnel, confer with them as well, as to what constitutes a harassment. What if I'm doing my work in a designated staff area? Well, if you're in a designated staff area, that is a non-public area. But there's some gray areas here. So let's say if you're talking about designated staff area, you're talking about like a workroom in the back of the library. Assuming there is a door that, gains entrance to that area, there should be a sign on the door that says, staff only, or this is not a public area, or something like that, to clearly demarcate that this is not a public area. Now, many of these problematic First Amendment auditors have a history of just barging into staff areas. And you can't always control people's behavior, as we all know, with masks and everything else. And so it's a matter of what you do if someone does that. And just like, again, you'd have a policy, and you would warn someone, I'm sorry, this is an area that is not open to the public. I'm going to have to ask you to leave. And if they refuse to leave, then you call your security, or you can call law enforcement and ask them to leave. And at that point, it could be trespassing. There's different things that law enforcement can do. And sometimes just the threat of law enforcement is enough to make them leave. Sometimes not. But, again, what I would recommend, and again, you would double check with, your attorney, is contact your municipal partners and see what they do. And then, when you warn the person that you are going to contact law enforcement, then the idea is you want to de-escalate the situation. So, I would back off. You could leave the space as a staff member if you're able to. Just go back to work. Just go back to your computer and do your work. Again, ignoring them can be the most effective deterrent. And the reality is, in a library, a lot of the information in a library is public record anyway. I mean, not personnel files, so, if you have someone who's trying to rifle through files, as far as physical restraint, there's nothing you're going to be able to do anyway. So at that point, you're going to want to call law enforcement. But most of the time, it's an intimidation thing that they're trying to do. And so ignoring them and going back to work is a lot of times the best method. But definitely, if you feel threatened, go to your problem patron emergency policy, contact security, contact law enforcement. Isn't Michigan a two-party consent state? Yes, being a public employee overrides that. This is not a question, because there's a couple of things here. This is not a question of recording like conversation or that kind of privacy or wiretapping. It is established that a public employee, in the context of doing their job, has no expectation of privacy. It's just like your work email. You have no expectation of privacy in your work email. You have no expectation of privacy, in the library on the floor when you pick up the phone, right? Other than that Library Privacy Act, with regards to any kind of reference question or information that's connected to a person's name, right? But if you pick up the phone and you say, Library of Michigan, this is Claire, may I help you? And then you repeat, okay, you're having a problem with figuring out how to draft this policy. Is it okay if I get back to you? That is perfectly no expectation of privacy in that conversation. Where the issue comes in is if someone is recording and they're recording the screen where you have a patron record up, or they're recording someone checking out material and the person's face is visible. But there is nothing that would prevent a library from having a policy to restrict that. Okay, it's how the policy is drafted, and that is something that your attorney can assist you with. So in a library, because of that time, place, and manner restriction, it's not a blanket right for someone just to walk in. But it is important that you understand, as a public employee out doing your work, there really is no right to privacy in that particular instance. But as I've mentioned, there are some other shadings here that could permit some policy making there. When that two-party consent comes in, and that's actually, it's been a while since I looked that up, but I want to say I think that's kind of a recent thing, that if you're in a personal conversation or you're in the back room with your boss, that's a different issue. But when you're out in the public and you're doing public duties, that's something else. If you're with your friends, or that's another story. Yes, there are some sample policies. When you say good, that's hard for me to say, because as I said, with this, you really want the policy to fit the library. There's lots of libraries that have policies that work very well for them. So I would say, from that point of view, there are lots of good policies, but you really need to kind of match the policy to your particular situation. Would board meetings have to be specifically addressed on a policy like this? However you typically do your policies, I don't think you have to have a whole board meeting on this topic. It could be the library director drafts the policy. It depends on how you normally do your policies and how involved your board wants to be. Some boards want to be involved in every policy. Some boards leave it up to the director. If your director drafts all your policies and then gives it to the board for approval, then that's what you would do. Your board definitely should approve. If you have a governing board, your board has to approve every policy, or really should approve every policy, unless they've delegated that authority to the director. If your board has delegated to the director and said, look, we don't care, you just deal with it, then the director, that's something a little bit different. But the board, as the legal representative of the library, if the library were to get sued, it's the board's names that appear on the lawsuit. Okay, so for that purpose, the board has to be able to approve policies. They have to be able to know and have a say in what they're being involved in, because they represent the library as an entity and its liability. But from a practical purpose, a lot of that just depends on the internal workings of the library and how you do policies. Do you have to convene a whole board meeting just for this to discuss it? No. You just want to follow your usual policy procedure.
Claire, sorry, this is Megan.
Yeah. Hi.
I meant about the actual recording or photographing of the board meeting.
Oh, because no, that's actually written into the OMA. Right. People have a complete right to record, or they don't even have to let the board know they're recording.
So if you had a policy banning like photography and recording, would you have to specifically note like exempting board meetings?
Yes. Yes. I mean, it would kind of be automatically exempted because it's in the law. But yeah, I mean, a board meeting kind of is a separate thing. But yeah, I guess if you have a ban in the library of, recording in any room, right, you would want to, probably wouldn't hurt to say that this does not include board meetings. I have a toxic board member that thrived on intimidating other board members and creating conflict for years. They also recorded all meetings, in their words, to keep people in line. There was calm and well-spoken. They knew what they were doing and were very good at it. Yeah, unfortunately, that's true. This is there are people like that. There are people like that in Michigan right now in libraries. And again, every policy isn't going to solve every problem. If board members, it's a little bit different because now you're getting into employee situation, and there are certain separate types of I guess I would say cautions or rights that employees have versus employers for purposes of recording. As far as like wiretapping and stuff goes, when you're in staff areas, there's supposed to be notice that staff are being recorded. So that's a little bit of a stickier issue outside of the public arena that we're talking about right now. And we can, talk about that separately in an employment type webinar. But yeah, that's a whole other issue. Yeah, recording computer screen. Yeah, yep. That would be a problem in the library. Again, that gets a little sticky because they're outside. But, library grounds are still library grounds. So, yeah, I mean, that's something I would discuss with your attorney as far as addressing, recording outside the grounds, because there is, as I said, there is a right to record public buildings from the outside. But again, there also is the privacy issue. And I think that's probably the more of the issue there, the privacy issue. So I would definitely address that with your attorney. I think there would be a way to put wording in there. But then, you can't draft a policy to count for every single thing that might happen. You'd have policies that are like 50 pages long. I think what's important is to kind of put that in the back of your mind as to how would you address that if you think that it is likely for that to happen. If that is something that happens in your community, then that is something I would definitely address with your attorney and just say, okay, how would we deal with this? And have that as something that, you know, again, you would work with your staff so that if that ever occurs, you know how to respond. Can auditors come behind the circulation desk and film or photograph? No, that can be a staff space. You, again, part of it is notification that this area is off limits to the public. And so that definitely would be a staff space. It also would be a library privacy issue. If there needs to be a policy about this for meetings, yes, I think I just addressed that. Yes, you can. I would definitely, if you have a global ban, I would talk to your attorney about inserting a line in your policy or putting a line in your policy that, you know, just to protect your butt, that this does not apply to public meetings, public board meetings. Okay. I think that again, one of the things I want to reiterate, and this is something that actually has been talked about a lot in view of COVID restrictions, and that is something that with policies, one of the things to consider is the should versus the can, right? And I'm not trying to get all preachy here, but this is coming up more and more with things that I deal with every day. And we actually did discuss this in the recent webinar we had with Ann and Mike about COVID restrictions that no longer exist. But I think it's very pertinent for moving forward and for things like this. When you have issues that can be very squishy, which, you know, a lot of these rights issues can be squishy and they can differ depending from community to community and political leanings. And I also think that more of this is going to happen because of the contention in our country right now, that one of the things that libraries really have to sit down and think about is, okay, you can have these policies, but should you? And that's one of the reasons I mentioned things like if you have architectural specialities in your library, or you have some special events where you want people to take pictures, it gets very hard to turn policies on and off. And then you run into uneven enforcement and allegations of discrimination. And just because someone walks in a library who looks like they're intimidating and who looks like they're going to be a pain in the butt and they have a camera doesn't necessarily mean they're a First Amendment auditor, unless they come up and say, I'm a First Amendment auditor, or their behavior indicates that. You know, so, you know, you want to kind of, again, have some consideration up front when you're establishing your policies, not later on when you're enforcing them, because that's when you can run into a lot of trouble. If you have an overall library photography ban, but yet you're letting people take pictures in the library, you're really opening yourself up to some problems, you know. And you may say, well, realistically, is that really going to happen, that someone's going to sue us? Well, you know, who knows? But, you know, we say in the Library of Michigan, it's not a problem till it's a problem. And you don't want to be in the position of, well, we didn't think it was going to be an issue, and oh my gosh, now it is. So it really is good to kind of do a little bit of forethought. And also, you know, you may have the policy, but you may say, okay, you know what, I'm just going to ignore this person. But again, these are some issues to also discuss with your attorney, and, you know, the dangers of uneven enforcement and unfair enforcement. But when you're drafting your policy, you know, I really feel that a lot of these issues are about behavior, not about intent, not about what their original purpose was. It's about behavior. It's not about them taking pictures of a staff member shelving books, or of a staff member, you know, being friendly at the reference desk or the circ desk. It's about the person coming up in your face, being intimidated and making you feel uncomfortable and making other people feel uncomfortable. So it's a behavior issue. And I think that's why it's very important that staff get trained on de-escalation, on how to deal with problem patrons, and that the library has a really good behavior policy and a procedure for what to do when a patron goes off the rails or there is, you know, patron behavior problems. So with that, it is 11:14. We're a little bit early, which I think is a record for me. So I want to say thank you very much for attending today. And I look forward to talking to you next month. And thank you very much.